I show 5 o'clock. Steve, we ready to roll?
We're ready to go. Everything is streaming.
All right. All right, we'll call to order then the McCracken County Fiscal Court meeting, October 11, 2021, 5 p.m. Video teleconference. And Madam Clerk, call roll, please.
Commissioner Jones,
I'm here.
Commissioner Bartleman,
Here.
Commissioner Parker,
Here.
and Judge Clymer.
Here. And Commissioner Bartleman, offer our prayer, please.
Yes, sir. Father, we just thank you for the blessings of this day. We thank you for the opportunity we have to meet and conduct the business of this county. We just pray you be with us as we make decisions that not only be good in the light of all the residents of the county, but good in your light too, Father. We also pray for our first responders who are out there keeping us safe. Just keep them safe and they perform their duties, Father. It's in Jesus' name we pray. Amen.
All right, then stand for the pledge, please. Join me. I pledge allegiance to the flag of the United
States of America,
and
and to the republic for which it stands,
one
one nation,
Under
under God,
indivisible.
indivisible, with liberty,
liberty and justice for all.
justice for all.
Seems as we had a little delay in there or something, but we got it done. All right, first up's the consent agenda.
I move we approve the consent agenda.
Second.
Discussion. All in favor, aye.
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 Opposed, no. That carries. Budget transfers.
It is ordered that the necessary cash transfers in the amount of $300,000 be made in order to pay county bills and payroll approved October 11th, 2021.
So made.
Second.
Discussion. All in favor, aye.
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 Opposed, no. That carries. Accounts payable.
It is ordered to approve the vouchers claims register from September 27th, 2021 to October 11th, 2021 to show county bills in the amount of $462,440.28 were paid.
So made.
Second.
Discussion. All in favor, aye.
Aye.
Opposed, no. That carries. Future land use plan amendment under discussion. Who wants to start off with that? Is that you, Steve, or Greg?
I will kick it off, Judge. We wanted to engage the fiscal court this evening with a proposed amendment to the county's future use plan. The structure of this, how it ordinarily works is if you're in general agreement with the direction that we're thinking about going, we can package it up, take it to the planning commission for their action, and then we'll come back to you ultimately to be put in the form of an ordinance. And what it all sort of relates to is the action we took a number of months ago when we embedded into our land use code the ability to allow solar facilities into the county. Prior to that time, had an applicant come forward that wanted to build, like, say, a solar farm. There was no mechanism in our ordinance to allow that. So after some deliberation, what we did was we authorized it in an ag zone with a conditional use permit, and we are currently processing one of those applications now. What has changed between now and then really is we're seeing a tremendous amount of activity in the county, far more than we thought would happen when this first came up. And what seems to be driving it here locally is really the presence of TVA in the old gaseous diffusion plant, whereas when the plant was constructed, there was lots of electricity that had to go to the plant. So that necessitated lots of substations and different electrical infrastructure in McCracken County. Getting access to those substations now is what seems to be driving companies to want to locate in the county. And as part of that, we're seeing a couple of things. One, they're not necessarily only gravitating to the areas that we have zoned. They're searching out areas that we have not zoned. That presents an issue in itself because it will spark future requests for zone changes. The other thing that we're concerned about is even if we are, so for some of the activity that's going on in unzoned areas, we will force them out to the ag zoned areas. And the ag zoned areas, we've taken a sort of second look at that and said, well, we could cover up future industrial opportunities. So we thought about how we might better protect the county from. There's nothing inherent. We don't think there's anything inherently wrong with solar farms, but what we do see from the industry so far is they can tie up land with a long-term lease, and what could be a good area for future industrialization could get covered up with solar panels, which frankly don't produce very many jobs. And then we could lose some economic opportunities because of it. So let me share with you, hold on, the screen, and I'll let Stevie take it from here. How does that look? Can you guys see that?
Yes.
All right. Steve, would you pick it up from this point?
I don't see him. Are you muted, Stevie? See him over here.
Sorry about that.
Okay.
What you see in front of you is the future land use plan of McCracken County. It's broken out into different districts, from the urban residential in the yellow all the way down to the industrial districts, which generally are purple. There are two different areas that are proposed for a land use change, a future land use change. One is in the upper left-hand corner, and that's from agricultural to general industrial. You will see the properties directly to the east already being existing industrial on the future land use plan. So they're all properties bordered by the Ohio River to the north, existing industrial to the east, and then the McCracken County border to the west, and then the Ogden Landing Road to the south. The second change or proposed change would be agricultural to a light industrial. And that's around 160 acres or so directly adjacent to the airport and directly adjacent to some existing future land use, which is light industrial at this time. We drove the entire area, looked at properties that are directly contiguous without a lot of residential, and there was 2 tracts that were identified for possible future industrial land use, for light industrial land use.
So light industrial would include solar panels?
No. We think both for heavy and lighter industrial that it would be better if the county reserved those areas for economic opportunities that generated building investment and job investment versus the jobless investment that comes with solar. Not casting aspersion on solar or saying it's necessarily wrong or bad, but for some of these areas, we may want to consider land uses that would create more job opportunities.
So the bottom line of what this does, it protects the land for industrial use and not solar, right? So instead of putting in a 500-acre solar farm we're protecting it for 500 acres of industrial development. Is that the bottom line of it?
That's the bottom line.
That's a good
What-
bottom line.
But what, I've only been contacted by 2 people about this. And what about out by the old Heath High School in that area? Or is that one of these areas we're talking about?
The folks that are out in that area, we currently did not zone that or include that area in our original land use regulation for solar. We from the beginning, we did not think that it should go into what we refer to as urbanizing residential or rural residential. That it was more appropriate that it be in the more sparsely populated areas of the county or the agriculture zones. So there is a group out in that area, and they know and understand that if they bring an application forward, it's going to cause the county, I think both the Planning Commission and the Fiscal Court, to reconsider whether or not we want to rezone that property. I don't want to hear that case right at this time, but that's what that one is going to be challenged with.
And I understand, and I guess my reservation about all of it, I mean, you know, these people, a lot of it, that land's been passed down in their families. They bought it a long time ago, and we're saying we're going to tell people what they can and cannot do with their property. You know, that kind of gets into an iffy. And I agree, the property along the river there, I mean, it's industrial property, but I have a tough time with telling someone you can or can't do certain things with your property. So,
Unfortunately, Jeff, that's what zoning does. It regulates it, so.
Well, of course, it does not prohibit a landowner. It doesn't say they have to accept solar panels. This is a matter of the solar panel farms or solar farms coming in and wanting to either lease or buy private land. And so if I'm a landowner, I've had it since granddaddy was little. Got it from granddaddy. He was once little. And I don't want to sell or lease my property. I want to go out there and kick around on it, farm it, look at it, whatever. You just don't sell it to them, or you don't lease it to them. The interesting thing that's happening, of course, is I can't remember the figure. It's a rather attractive rate that the solar farm folks are offering to landowners to lease their property in excess of what a lot of them are currently or in the future probably would recover from farming or whatever other use. And so it's attractive to the landowner if he or she doesn't have a concern about holding on to it, to sell to the solar farm, and so that they make more money. And then, in fact, one of the programs is as a plan of sort of stretching solar panels out through the residential area of Granville there. And so some landowners will be happy to try to get maybe even double what they could for agricultural use, while their neighbors will not like the fact that solar panels are going in next door to them. So some people be happy, some be sad, but certainly we're not saying because a area is zoned allowing solar panels in an agricultural zone that landowner must sell or allow that. They still have their private property rights.
I have one question about the map amendment from the actual map itself, and another one about the process. Maybe if I ask the one about the process first, what's it take for us to actually amend the land use plan?
Greg, do you want to take that question on?
Okay, so if you all decide tonight that you want us to move forward with this, then I will take this before the planning commission process theirs. I run an ad in the legal classifieds of the paper notifying that we're having a public hearing. We will have a public hearing at our October meeting later this month. We will present the amended future land use map that Steve showed you. The planning commission will look at it. They will decide whether they agree or not, and then they will make that recommendation to you all. That map will come back to the fiscal court with the planning commission's recommendation to approve it or not approve it. And you have to decide, do you want to follow their recommendation or go against their recommendation? But that's the process.
So, and as our statute said, I guess, how does this plan amendment affect to either say no to a solar farm or yes to a solar farm?
It would affect it by then, in addition to changing the land use plan, we would have to add maybe as little as a sentence to the zoning text to not only be zoned, but also be in compliance with the county's future land use plan.
So we're envisioning basically a situation ultimately in which if you've got land zoned agriculture and the predicted future land use plan is agriculture, then that land would be permitted for a solar farm. But there'd be some land that is zoned agriculture, but not anticipated it will be agriculture forever, that would be accepted. Am I understanding that right?
So the property that is zoned agriculture with the future land use designation of industrial, you would not be able to use that in the future.
I got you. But what if it was, okay. And that would be our so then my other question, Steve Irvin, is when looking back at your map, all right, so we've got the purple, which is industrial, and we've got the circle there, the area on the river that's green that we're gonna say that we know the other bigger circle.
And it's just the crosshatched area.
Right. All right. So then back, I guess back east, we've got on the other side of the purple, is that agriculture there?
Yes.
What? And is the line across the Ohio River, is that the train bridge?
No, this is I-24.
Okay.
Train bridge is right here.
Okay. Why would we not want that spot too?
Sort of what's different about this area right here, Commissioner, is floodplain.
I got you. Okay.
While this area has a significant amount of floodplain as well, pretty much everything to Noble Road here, between Noble Road and the Ohio River is floodplain. It's future development for anything that's intensive is somewhat limited.
So if this is approved, everything to the west, what's purple in the circle, everything there would be purple. Is that right? If this is recommended by the planning commission?
Correct.
Actually, does it have to be recommended by the planning commission? Just has to go before them.
Goes before the planning commission and a public hearing. They can do three things. They can issue you, they can disagree with it, they can agree with it, or they could modify it and send something else back. And then you take it up, and ultimately it's the fiscal court's land use policy, and you can accept it or change it.
We can disagree with them if we want to.
Always, yes. We don't frequently, but sometimes it comes to that.
Are there any solar farms right now being discussed in the circle area?
None
Or
that
are
I'm
we-
aware of.
So we're just being proactive ahead of that to make sure it doesn't go there.
Yeah, we don't want to, I think, chase them out of the unzoned areas and say you can't do it here, and then they end up in another area for which we similarly are concerned about its location.
Can a solar farm be constructed in a floodplain?
So that question has come up with at least one of the companies that's out here looking, and sort of the tone and tenor I got was they're avoiding that to the degree possible. The one that's already in the zoning and permitting process is completely outside of the floodplain. So I think generally almost nobody looks to put anything in floodplain, and from a development standpoint, I think that's pretty wise for obvious reasons.
Is the one that's in the planning stage, is that outside of a prime economic development area? I mean, are we losing that land to economic development as one that if we waited, it would be good?
Yes, they have identified some areas I think we have already placed in our future land use plan as industrial.
You mean that we're going to put solar farms in industrial?
Yes.
So the one that's in the planning, that could be better use as industrial land?
Yeah, so the concern, going back to the concern is, so with solar farm projects, and they're great, they're fine, but after the initial burst of construction, they're basically jobless. There's not a lot of employment surrounding those, and we have identified some key areas, particularly near busy railroads and near the river, that look like their better future use for those lands is industrial.
If they put in a solar farm, do they pay property taxes, or is there any kind of exemption for solar farms on property taxes?
So this is a bit of an unknown question, even among the developers, what that's going to look like. I don't know. I don't know if what ends up, if it's land plus, and that constitutes an improvement, or if that's just equipment out there and it's not necessarily improving the land like a building would. You're just left with the land value as what's taxable.
Say 20 years, it may be worth less because it's got a big old solar farm on it.
So the equipment's not taxed, Steve?
I don't know yet how the state is going to look like that. I just don't know.
Is that solar farm, is that a done deal, or do we have to approve that or disapprove it?
So the one that's in permitting already, that one will not come before you. So that's what's critical about setting up the regulation correctly, is so that we know downstream with the various zoning boards, we're processing these in a manner that's consistent with what the desired county policy is.
Can you put the map back up and show us where that solar farm is that's in the permitting?
Got a number of hearings. It's along McKendree Church Road, and it's just west of the DOE reservation and the West Kentucky Wildlife Management Area. This general location here.
Steve, right there where the light green ag meets the dark green rural residential, that is the southern boundary of it. The purple is the eastern boundary. And then, yeah, right where your mouse is, that is the western boundary of it. The northern boundary is 600 acres total, 400 acres approximately planned for covered in panels.
If that solar farm wasn't as far as long as it is, would you be recommending that for industrial, Steve?
No, I don't think our opinion of that area has changed. I think that one is perfectly appropriate.
So I think it's clear, but to be sure, as we know, a industrial project could bring 500-600 jobs on 500-acre site. Those jobs in the averaging in the $100,000 range. The 500-acre solar farm will bring a good number of construction jobs for a while to get the thing built, but afterwards it's 4 or 5 jobs and relatively low pay. And so we obviously would rather have 500 jobs at 100,000 each than 5 jobs at 30-40,000 each.
So we're not, it's so far along, we could not stop that plan, Steve.
One west of the DOE reservation?
Yeah.
No, but I'm not sure why you would.
To put the judge's 500 jobs on there, if that ever came to that.
Well, that's where that's the potential for those other sites that we're grabbing to prohibit solar farms along. We focused on along the river, out of the floodplain, near rail, near Riverport, and then we also through some areas around the airport in hopes that once our new terminal gets in, we're going to be focusing on the aspect of bringing some projects in there, airport related, aeronautics, that sort of thing. We're just trying to make sure that we don't look back in a few years and say, we should have zoned that for big growth, big industry, instead of there being, whatever, solar panels or something else.
Steve, is that size solar farm big enough to help attract industry?
The existing one that's in permitting right now?
Yes, sir.
I would think so. It's a 50 megawatt plant.
So we, in talking to projects, we learned that they, particularly under the current federal administration, there's a tremendous push for green, for renewable energy, solar, wind, hydro. And so the solar panels, project developers can go after federal tax incentives. There's 45Q tax incentives that the federal government's putting out. They've even increased the amount for projects that would traditionally be maybe coal-fired or primarily coal-fired fossil fuels. And if they will instead put some solar in there, put some green energy, there's large incentives for that sort of thing. So certainly solar is important. And I think we want to be open to allowing them to come and welcoming their coming. But again, it's just the fact that we zone an area agricultural that would allow solar panels we certainly are not going and telling private owners that they have to allow solar panels. The solar farms are trying to entice the agricultural, probably farm, maybe just hunting, maybe just, just land people like to have, to by offering a large price for lease or sale, that they can acquire that land, but the landowner certainly can decide not to.
Will they sell their power to TVA or Big Rivers?
Big Rivers or Jackson Purchase. That was the current one that's under permitting is going to Big Rivers.
Okay.
Any other discussion about it?
Do we need to approve this as a recommendation to the planning commission, or will it just go before then we get hear from them? What do we need to do, Steve?
Yeah, I think I don't think there's anything we need to vote on this evening. You'll get your bite at it when it returns.
Okay.
Expect for the public notice.
What about the public notice? You say explaining?
Well, I don't know. I'm just being a lawyer, and I'm not the lawyer. Never mind. So I guess it sounds like this public notice will be significant.
I guess what is it, Greg, is to require the standard publication in a major newspaper, all that, or what?
Yeah, and an ad has to run in the legal classified 7 days prior to the meeting, no more than 21 days prior. We're sitting at 14 days out right now. So it would, if y'all want me to, it would run in the next week. So everybody'd have at least 7 days notice of that public hearing. And that meets the requirements under state statute.
So you've got time to get to the planning commission before our next meeting, is that right? Have it
Yes, sir.
on and back to us. So in 2 weeks, you can
So
get it advertised, get it before the planning
our
commission.
meeting, our meeting, yeah, it'll go before the planning commission October 26th.
Okay. Can you advertise before the planning commission acts? Does the planning commission have to, or can you do that on your own, advertise for a hearing?
I write the ad and submit it to the newspaper.
Okay. But the planning commission does not have to, I'm sorry for asking this, but the planning commission does not have to approve advertising a public hearing, right? You can do that in anticipation of the public.
No, they do not.
Okay, thank you.
As a courtesy, I notify the chair before it runs because it does have his name on it. So he will know when I write the ad. But the whole commission does not have to be made aware and vote on it. No.
Okay.
All right, anything else? All right, we'll move on then to court orders, 5A.
It is ordered to approve the September transient room tax in the amount of $321,205.64 to be dispersed as follows. Paducah CVB, $94,239.75. Convention Center, $64,007.71. Sports Tourism Commission, $97,776.32. Escrow Fund, $65,181.86.
So made.
Second.
Any discussion? Oh, and, I think, don't you, Commissioner Jones, kind of keep a tally on that? Or is that up, down? Is that about where we usually are?
So it's I think we were 106,000 last month, but it's still close to 6 digits. So it's down just a tick.
Yeah. And also, was it the meeting, what the magistrates and commissioners meeting, you made a presentation to across the state?
I did. I was asked to give kind of an explanation of what we had done here, and there are a number of other counties that are either have or thinking about following our path. And as part of that presentation, I was maybe interested. So the total collected so far for Sports Tourism Commission, since we have started collecting this revenue from out of town residents who stay here, is about 1.6 million.
So I will, you gentlemen probably hear the same thing, but when I go about these statewide meetings and whatnot, people have a great interest, not just on this, but frankly on what we're doing in McCracken County on various things. But certainly they're interested in the sports tourism and the transient room tax and that sort of thing. And so, in fact, I was with the Secretary of Economic Development for Kentucky just the other day. He was here, and he was saying, I hear a lot of things really good about what you guys are doing, that you get involved and getting things done down here. And so it was a nice compliment. So 5B, or did we didn't vote on that?
No, sir.
Okay. Any other discussion on the 5A? All in favor, aye.
Aye.
B,
It is ordered that an accident and sickness policy with disability benefits for the policy period November 8, 2021 to November 7th, 2022 be purchased through Peel and Holland for an annual amount of $1,395 for the emergency management volunteers.
So made.
Second. Steve, is that the total cost of the policy, or is it that much per volunteer?
Oh, that's the total cost. Once upon a time, the state used to cover all potential or all injuries that occurred among the volunteers through its workers' compensation program, but they changed that and they dropped training missions and some other activities. And so this is just really supplements that part when we're not on an official state-sanctioned emergency.
that's the thing we had talked about some time ago about it was risky or unwise, whatever word you want to use, to use some of the volunteers for various things. We would like to use them for safety purposes, but if it wasn't a bona fide or declared emergency, we couldn't, because there was no insurance to cover them if you got hurt. So for $1,400 annually, we can, gosh, I don't know, get tens of thousands of dollars worth of benefit from them, and including extra training and that sort of thing. Any other discussion? All in favor, aye.
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 Opposed, no. That carries. C.
It is ordered that McCracken County Fiscal Court adopt the recommendation of staff to accept the Humana proposal for group health decrease of 4.92%, dental, no change, and vision, no change coverage as presented by Peel and Holland. In addition to continuing to offer flexible spending account, FSA, and health reimbursement account, HRA, a health savings account, HSA, option has also been added to the structure.
So move.
Second.
Discussion.
Hey, kind of hats off to the Peel and Holland. That's really good. We're getting 5% lower rates. That's that's a great thing.
I think this demonstrates the change we made a few years ago, going with Peel and Holland through CAECO was the right thing to do. And we probably should have done it before we did, but we did it now and it's saving us money.
We've got Heather Nestler and on if we have any questions or if you want to make any comments, and Michelle Fellows, our HR director, is on here too. Good time to ask questions. Heather, you're muted.
Sorry, Michelle will probably echo my comment that your employees have worked hard and have engaged with the wellness plan, which has helped us with that discount, helped the employees to earn that discount, but also they're earning rewards through the wellness plan with Humana. So kudos to you and the other employees for that piece. There was a little bit of an increase last year. So with this decrease, we're almost even with where we were before. So
Last year, before we changed, we were facing an increase of, I think, 15 to 20% if we'd have stayed with the other company. So we're still less than what we would have been if we hadn't made the change.
true.
I've got questions, Heather, but I'll ask that when I have my meeting with you. You know what I'm asking about.
Okay.
So I won't bore everybody with asking about those things. now,
Okay.
So you can be prepared. We always are, but thank you.
Michelle, anything?
Oh, I just think the HSA option is a great advantage for our employees. I mean, there's such a tax advantage to that. There's flexibility, investment options. So I think it's a great added piece for the county employees.
We're continuing the HRA and the FSA and adding the HRA, right? HSA. Is that
That's
correct?
correct.
Okay.
And so we'll work out a schedule to sit down. I think in our plan to go one-on-one with our employees if they wish to get guidance on what they might want to do and what's best.
Yes, and we actually have met and talked about doing education, especially focused on the HSA and the benefits of that, like Michelle was saying, with the triple tax advantages ahead of open enrollment. So we'll probably do enrollment mid-November to allow time for employees to receive and digest that information.
Anything else? All right. Thank you, ladies.
Thank you.
So all in favor, aye?
Aye. Aye.
Oh, it's not. Feel you got a little tickle in your throat tonight.
Yeah.
All opposed, no. That carries. All right, D.
It is ordered to authorize the judge executive to execute a quitclaim deed with the Joint Sewer Agency for property located off of James Sanders Drive.
So mate. Second.
Okay, discussion there.
So who are we conveying this to? It says with the joint sewer. Are we conveying it to them or with them?
We are conveying it to them. The Lone Oak Sanitation District owned a piece of property that when they disbanded, they gave the property to the fiscal court. When we did the interlocal agreement with the city of Paducah to form the joint sewer agency, all the assets went to the JSA. The fiscal court clawed this piece of property back, wanted to keep it for whatever reason, and then later decided to give it back to the JSA. And then the court voted to do that, except for there was a bust in the description. There wasn't a plat. It was a deed, and there was evidently an error in the deed, and this cleans that action up by fixing that problem.
Sam, do you got any problem with the word with? It confused me.
Yeah, and it didn't cause me any concern because I took that to mean that we're entering into an agreement with JSA on the purpose of transferring property.
Okay, right.
And it just cleans up the deed. JSA was trying to sell the land and they found out there was a technical problem with the deed. They're just cleaning that up and that land will be sold.
All right, I'm cool. Thank you.
All in favor, aye?
Aye.
Opposed, no. That carries. Let's see, board appointments.
It is ordered that Dawn Arnold is appointed to the Board of Assessment to serve a 3-year term beginning November 1, 2021, and which expires on October 31st, 2024, subject to further orders of the court.
So move.
Second.
Discussion. All in favor, aye.
Aye.
Opposed, no. That carries. E.
It is ordered that Jerry Gifford is reappointed to the Melbourne New Hope Fire District Board to serve a 3-year term beginning November 1, 2021, and which expires on October 31, 2024, subject to further orders of the court.
So made.
Second.
Any discussion? Can't miss an opportunity to, praise our fire folks, do a lot of good work for most of them, get no pay at all. We appreciate that. All in favor, aye.
Aye.
Opposed, no. That carries. C.
It is ordered that James Adams is reappointed to the Melbourne New Hope Fire District Board to serve a 3-year term beginning November 1, 2021, and which expires on October 31st, 2024, subject to further orders of the court.
So made.
Second.
All in favor, aye.
Aye.
No. That carries. D.
It is ordered that Donald Powers is reappointed to the Melbourne New Hope Fire District Board to serve a 3-year term beginning November 1, 2021, and which expires on October 31st, 2024, subject to further orders of the court.
So made.
Second.
Any discussion? All in favor, aye.
Aye.
Opposed, no. That carries. Resolution.
It is hereby ordered that resolution number R 2021-22, creating an energy project assessment district, EPAD, within the county pursuant to the provisions of KRS 65.205 to .209, and establishing a program to advance conservation and efficient use of energy and water resources, and authorizes the judge executive to execute all documents necessary to complete said district creation.
So made.
Second.
Discussion on that. We've got some folks here with us. If we have any questions, I think we do, don't we, Steve? For the EPAD.
We do. If you have any
Steelman.
questions, Laura Steelman from Brown Frost and Todd is with us this evening, can answer questions about EPADs, general and specific.
All for having us.
As I understand, the
Ben
assessment is only placed if somebody requests it. It's not an assessment on everybody. It's just if somebody's putting in a development, they can request the assessment.
Yes,
Is that
sir.
correct?
Yes, sir. So the statute, so Kentucky authorized EPAD enabling legislation back in 2015. And it can only, an assessment can only be placed upon a request by the property owner to do so. The county cannot unilaterally place this assessment on the property. You're right. Yes, sir.
Then there in the right lower secret square, Ben Spees that has requested this for his company. Mr. Spees, you want to?
Correct. Yes. Thanks for hearing us. But we the project that we're looking to put in place here is a senior housing community. It's 56 assisted living with a personal care license and 23 memory care units. It's on I believe it's North Friendship Road and New Holt Road, right over there. So it's a project that we're really excited about. We've actually done this project in Bardstown, Danville, Winchester, got one under construction in Shelbyville and Hopkinsville, and this would be our sixth one in the state. So very excited about this project.
As I understand, the advantage of this is that you use this assessment to guarantee the loan and you get a better interest rate on your loan. Is that correct?
We do. It helps in the overall capital stack that we put together. So we get our senior debt through our financial lender, and this allows us to put another layer onto that capital stack. That's a lower interest rate, non-recourse assessment. That it just really offers a lot of flexibility into the project in terms of the overall development, and it also allows us to capitalize a little bit on some of the energy efficient construction items that we're putting into place as well to conserve energy and make these systems run a lot more efficiently.
Right. And you pay the assessment, you'll pay the assessment to yourself in a sense when it gets through the process, right? So.
Correct. Yeah. I believe, Laura, you can correct me if I'm wrong. It works almost hand in hand with the property tax assessment that we would get each year.
It does. And so I think in this project, Ben anticipates repaying the loan over 25 equal installments. So the amount of the assessment will be set and it will not change over that 25-year period of time. And it will be due and payable contemporaneously with taxes there.
So does it prohibit, you say that is the assessment set for 25 years, or is it just this energy part is the assessment?
So let's just say they borrow a sum of money. We will divide that sum by 25, and they will make that annual payment to the county along with the taxes. And then the county will have 30 to 45 days or whatever the county agrees to remit that payment when they receive the taxes to the lender that's provided the upfront financing to Ben and his group to do these energy improvements to the building as they construct it.
Ben, that's a 24/7 operation. How many people you anticipate employing there?
Once we get the project fully stabilized, which is about 92%, it's roughly 50 jobs, give or take, part-time and full-time. You've got them ranging from your executive director level position, which is a very high-paying job, down to wait staff and nursing care providers. So we're anticipating once you get to that stabilized point, it's roughly $1.5 million a year in annualized salary.
All right. I missed something. So, all right. So we're going to create additional equity because you're going to be more energy efficient. We're going to allow you to go to a lender and he's going to give you money. But then, Laura, you said the county's going to make the payment out of the.
Well, the county will collect it, and just like you would the taxes. So the mechanics of how the county wants to actually, if you want to put the assessment on your tax bill, or if you want to include a sheet of paper with your tax bill, it will be accompanying your tax bill every year. And it will be due and payable on those same time periods. So if your taxes are due December 1, I'm not sure, in McCracken County how you do it, the assessment would be due December 1. And then the EPAD lender would then get a check from the county for whatever that dollar amount might be over the 25-year period. So the lender's going to upfront the money to Ben and his group to do the construction. So that the HVAC and the windows and the doors can meet whatever those energy efficient requirements are. And then the EPAD lender is paid back over 25 years as that assessment is added to the bill, levy and collected, and then the county cuts a check for that assessment directly to the lender.
Laura, if they don't pay their taxes or they're late, we're not responsible, are we? We only pay it if the property owner doesn't pay their taxes. We have no obligation, right? Only if they pay it.
Yeah, there's no cost or obligation to the county. Now, so there's two resolutions in front of you. So 2021-22 is the resolution that's required to create the district under Kentucky statute. And then the next resolution, 2021-23, 3 is related specifically to Ben's project. Because the county is the political subdivision, you all are the ones that have to place the assessment according to the statute into the property tax rolls on the day that we close this financing. So the first resolution sets up the EPAD district that could be used at your all's leisure for any other property owner that could come before you. But the second resolution is specific to Ben's project.
So let's say somebody else wants to do this. Do we have to do another resolution for every time somebody wants to do this?
Well, not to set up the district. Let's just
Right.
say that another property owner comes. Mr. Jones, in my opinion, it would be prudent for the lender to make sure that he had a resolution on the books of the county to do so. But you all could also take this program that we're setting up very in basic format for you all under the statute, and you could, let's just say it becomes very popular. You could put additional parameters in there, but this has been structured so that the judge or his designee can accept these applications within these parameters that have been placed in this program. That if I were coming back to you, I would want my lender to have a separate resolution from the entire fiscal court.
I'm sorry, and few more follow-ups, because it sounds like we're going to add some additional requirements to government jobs.
Sure.
And I hate to sound like, I realize we're not running a for-profit business, but somebody might come to us one day and say, well, I'm overworked. We're going to need to hire somebody else. Does the county collect any additional money for their role in this?
Yeah, so the statute allows the county to collect a fee for its services, yes. The statute limits that fee to whatever's reasonable in the ordinary course to cover your expenses. So whatever agreement that the county wants to reach with the developer for this project, let's just say even numbers, let's just say that you all charge, I don't know what you think it would cost. Let's just say $500. And let's just say that Ben owes the EPAD lender $100,000 annually for the 25-year term. The actual assessment would be $100,000 plus the $500 owed to the county. When the money comes in, the county would keep the $500 fee related to your expenses and then remit the $100,000 to the lender. Now, you can at any time under the statute, if this becomes, let's just say this takes off and there's all kinds of property owners that want to take advantage of that, the county can amend this EPAD program to change that fee structure if the $500 does not cover your expenses. But for this project, changes would not be retroactive.
Okay. All right.
So yes, we can certainly accommodate a fee. Yes, sir. Mm-hmm.
Okay. Then, all right. So let's say we do this, and then for other reasons, Ben, I'm gonna pick on you, Ben's property becomes worth more money. And sometime in this next 20 years, we want, or the PVA, not we, the PVA says, time to reassess you, Ben. Does he have the effect of a moratorium for the life of this, or can he be reassessed?
This assessment has nothing to do with the property value assessment on the property.
Okay.
And that can be assessed in the ordinary course. And
All right.
whatever appeals or processes that would be available to Ben as a property owner as it exists now, or regardless of whether the EPAD is in effect. But the EPAD actual assessment will not change, whether that property is worth $1 million or $500 million. The money owed to the EPAD lender and the fee that the county charges will remain the same while this assessment's outstanding.
Okay. All right. Thank you.
Yeah.
I think I understand that the amount collected from this assessment does not change. Doesn't matter what the value of the property is. They get $100,000 a year. They get $100,000 a year for 25 years, even if the value of the property doubles. Is that right?
That's right. Yes.
Okay.
Mm-hmm. It's truly a repayment mechanism. Because as Ben mentioned in the capital stack, when Ben gives a mortgage and gives, all the collateral to the senior lender, this is a secure option to complete that capital stack EPAD, the statute is not specific, but as a general rule, we see EPAD lending makes up typically about 20% of these projects. That's the amount that EPAD lenders are willing to extend based on the assessment method. So.
And Ben, you're required to meet certain criteria for energy and water efficiency. Is that right?
Correct. So we put together, we take our plans and we give them to a firm who does an audit, and they then determine, out of all those construction costs and those dollars, which ones are actually applicable and meet certain energy requirements in order to get the financing. Mm-hmm.
And your new construction?
Yes, sir.
Laura, and is this available for a guy with an old law building to refinance as well? I mean,
yes, rehabs are appropriate also. So all property under the Kentucky statute, except for residential of less than 5 units. So an individual property owner cannot come to you all. Many states have allowed residential owners to take advantage of this. In particular, California and Florida. We see this a lot in other states. In California, for solar panels, it's funny that you all were talking about solar panels, but solar panels on individuals' homes or earthquake resistant measures, we see a lot. Financed hurricane-proof buildings. But in Kentucky, any property may be rehabbed or new construction, except residential of fewer than 5 units. So yeah.
Ms. Stillman, we had discussed, then we land on making this program available in the unincorporated area of the county. In other words, anywhere in the county except within the city limits.
That's correct. Yes, sir. Mm-hmm.
We believe that it'd be best left for the city to decide if they want to offer that program and not as the county, although the city's in the county, of course, not to make that decision for them.
Yes. Yeah, so as the resolution sets up, this EPAD district applies to the unincorporated jurisdictional boundaries of the county. So anyone within that jurisdiction could come before the fiscal court and ask that this similar type assessment be placed on their property if they'd like to. You're providing the service to the entire county in this resolution.
Well, does future annexation create a problem at all?
I don't think so. I've never had that question before, but I think that the way that we've generically described the jurisdictional boundaries at this point, I think it would encompass future annexation. But certainly if that ever comes up, we can revisit that at the time. Kentucky statute is very simple compared to other states, and I'm not a real estate expert as far as annexation goes, but I think that the spirit of the statute would in fact take that into consideration, yeah.
I suspect the city comes on board with it. In fact, I was with the mayor this morning. I didn't think to mention, maybe they will, maybe they won't, but it's a nice offer for existing or potential businesses, I think.
Well, I mean, I think it's certainly a business development tool. It's fairly new in Kentucky. As I mentioned, the enabling statute was adopted in 2015, but it provides a service and also a way to make sure that you all have quality constructed buildings within your communities. And like I said, Ben's project is going to create jobs. So, and I think an assisted living facility is also, a service that many citizens would appreciate.
All right. Anything else? All right.
Thank you. Look forward to your development, man. Appreciate it.
Thank you. Thank you.
We've got to do this. We didn't do this specific resolution yet, right?
Sir, you need to take a vote on A.
Oh, I didn't take a vote on A yet.
No, sir.
All right. All in favor on A?
Aye.
Opposed, no. That carries. And then B is the specific, you want to call it the bin provision? What is it? DMK? Is that?
Yes, sir. Yes, sir. DMK development.
Okay.
It is hereby ordered that resolution number R 2021-23, levying a special assessment for the purpose of acquiring, constructing, and improving certain energy projects in cooperation with and upon request of Paducah Senior Partners LLC, providing for the deposit of the proceeds of the assessment, assigning the assessment to a designated lender, authorizing the execution of an EPAD agreement with the property owner, providing for any adjustment to the assessments in any fiscal year by the county fiscal court, and taking other action related to the imposition of the assessment, and further authorizing the judge executive to execute all documents necessary to complete said project.
So move.
Second.
Other discussion?
Let me ask one question, Ben. If you own this development for 10 years and decide to sell it, does the assessment continue for another 15 years? Or when you sell it, does it sell up this loan and the assessment stops?
Yes, sir. It does. It transfers with the property. So
Okay.
if it comes in and buys it, then it would transfer with the property to the new owner.
Well, I guess you could pay the loan off early if you wanted, but according to the terms of it, if you wanted to.
Correct. Yes, you could pay it off early if it made sense.
Okay, good. Thank you.
Yes. And all in favor, aye.
Aye.
Opposed, no. That carries. All right. Well, Ms. Tillman and Mr. Spees, thank you for being with us. Look forward to working with EMK and senior partners.
Well, thank you all so much. And thank you,
Very
Mr.
nice.
Doolittle. I really appreciate it. Thank you all so much. Have a good night.
All
Yes,
right, you too.
thanks.
Uh-huh.
Ordinances.
It is hereby ordered that pursuant to KRS Chapter 67, the first reading of ordinance number 2021-15 shall be conducted in summary format as follows. McCracken County, Kentucky, McCracken County Fiscal Court, ordinance number 2021-15. An ordinance amending the McCracken County Administrative Code by creating and enacting a new section 3.9 entitled Open Records Policy. Summary, the action taken by the present ordinance amends ordinance number 2021-09, which repealed and replaced ordinance 2016-08 and all amendments thereto. The administrative code is amended by the creation of a new section 3.9 entitled Open Records Policy. Certification, it is hereby certified by the McCracken County Fiscal Court that the present summary represents an accurate official statement of the main points of and contents of ordinance number 2021-15. Public inspection, a true and correct copy of ordinance number 2021-15 shall be made available for public inspection in its whole and complete form by the McCracken County Judge Executive's Office during ordinary business hours.
So made.
Second.
Discussion.
Steve, I assume this is just to bring us up to date with current KRS, is that right?
Correct. And this closely mirrors the sample policy that the Attorney General included in the requirement that we have this policy.
Any other discussion? All in favor, aye.
Aye.
No, that carries. Don't have any executive session we need, do we, Steve? No? All right. Is there a motion to adjourn?
So
So
made.
moved. Second.
Motion second. All in favor, aye.
Aye.
No.